So, State versus Winegardner asks us to do a deep dive into one of the provisions of the rule that allows a prior conviction to come in to impeach a witness. And we know that that if the prior act is a felony, then there are these balancing rules that we apply depending on whether the witness is a defendant or not, and depending on how old the judgment is, and depending on whether the judgment involved a juvenile at the time or not, or it was a juvenile conviction, to be very precise. A juvenile can be convicted of an adult crime. Juvenile convictions, however, are sealed. And so we know that if it's a felony, that there are all these different ways we go about analyzing the proper use of a conviction to impeach the testimony of a witness. But what if the prior conviction is for a crime of dishonesty? We know that regardless of whether that's a misdemeanor or a felony, regardless of whether the person served any jail time or not, then that will come in, provided it's not more than 10 years old. The provision, though, has a certain wrinkle to it, as you knew that it would. So in Winegardner, the defense tries to bring in the fact that the witness against the defendant has a prior conviction for shoplifting. It's a misdemeanor conviction, so we don't get to bring it in under the felony provision. The question is whether shoplifting is a crime of dishonesty. Now, remember we saw back in the Segovia case that the court there held for the purpose of Rule 608 that you could ask the witness about shoplifting because it involved trying to get an advantage over someone else, and that under this middle approach to how we view crime, or not crimes, but acts of dishonesty, that it qualified under that interpretation by the Colorado court. This is an Arizona court, and so we have a difference in jurisdiction to begin with, but more importantly, we have a different rule. We're now talking about not whether you can ask the witness whether he or she has committed an act of shoplifting. You're now seeking to offer extrinsic evidence. You're now seeking to offer the certified judgment of conviction for that prior act of shoplifting. That takes us to Rule 609A2. And let me read it from the book so we make sure we get it precisely correct. And actually, let me share the screen so you can read along. There you are. And it's actually, let me highlight this guy in yellow. So the rule provides that for any crime, regardless of the punishment, the evidence must be admitted if the court can readily determine, that becomes the operative phrase in this case, readily determine that establishing the elements of the crime required the prosecution to prove or involved the defendant admitting a dishonest act or false statement. So what exactly does that mean? What do we get from those very legally operative terms? It means that unlike in the shoplifting case, where the court, the shoplifting case in Colorado, where we were asking the question of whether you could ask the witness, had you committed an act of shoplifting, when we're now seeking to offer the certified judgment of conviction that shows the shoplifting, we have to now show that either the elements of the crime involved dishonesty, and shoplifting doesn't, or the particular way the defendant committed the crime involved dishonesty, lying to the person. Is there anything in your bag? No, there's nothing in my bag. Would be an example of facts of shoplifting that would involve necessarily an act of dishonesty. It wouldn't have to be in the conviction itself, in the elements of the crime itself, but that's the easiest way to show it: perjury, fraud, that kind of thing. Elements themselves showing dishonesty. But you can also, if the defendant's plea colloquy I lied to the clerk about nothing being in my bag. If you can show from the record very clearly, readily, that the facts of this crime involved dishonesty, the court can obviously see that. Then, so like in the plea colloquy, or perhaps even in the trial transcript itself, if there is an admission by the defendant, or that the facts establish very clearly that the defendant committed an act of dishonesty, then you can show that this is a crime of dishonesty under this provision, and it will come in. The easiest way to bring in a prior conviction as a misdemeanor would be something that clearly has as an element an act of dishonesty, fraud, perjury, etc. But if you can quickly and readily show that the circumstances under which this happened required the prosecution to prove, because of the nature of the offense, the nature of the way it was committed, required the prosecution to prove an act of dishonesty. You can show this from the indictment, you could show this from the plea colloquy. If that can readily be demonstrated, then you can in fact bring in a misdemeanor conviction for shoplifting. The defense in this case was unable to make that showing, or did not make that showing, and so the court holds in this case that you could not, under Rule 609, bring in a certified judgment of conviction as extrinsic evidence of the crime of shoplifting. Now, we don't know if Arizona interprets Rule 608 in the same way that Colorado does, where under the Colorado interpretation of 608, the defendant could have asked the witness if he or she had been ever caught shoplifting. If Arizona follows the same rule or the same interpretation of 608 as Colorado does, then the question could be asked. But under 609, under the Arizona interpretation of this rule, which is the majority rule, shoplifting by itself cannot be offered as a crime of dishonesty unless you show something more, something that shows that the nature of the way this crime is proven demonstrated the defendant's slash witness's dishonesty. Defendant at the time of the conviction, and the just ordinary old witness or defendant witness for the purpose of bringing in the evidence under the prior conviction under Rule 609.